All rise, veuillez vous lever. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
Yeah, thank you very much. Good afternoon. Would the court officer please call the case?
Good afternoon, Your Honor. Situation in the Republic of Côte d'Ivoire in the case of the prosecutor versus Laurent Gbagbo and Charles Blegude. Case reference ICC 0211-0115, and for the record, we're in open session.
Thank you. My name is Piotr Hofmański, and I am the presiding judge on the appeal 0810 arising from the case the prosecutor versus Laurent Gbagbo and Charles Blegude. The other judges of the appeals chamber on this appeal are Judge Kuniko Ozaki, Judge Sanji Masonono Monageng, Judge Howard Morrison, and Judge Chang Ho Chung. I am joined today by the legal staff of the appeals chamber, Mr. Dražan Jukic, Mr. Anthony Abato, Mrs. Nora Godkin, and Mr. Jessica Prescott. May I ask the parties and participants to introduce themselves for the record, starting with the Office of the Prosecutor.
Good afternoon, Your Honour. I'm here today with Reinhold Gallmetzer, Appeals Counsel, Melissa Pack, trial lawyer, and Matteo Costi, Appeals Counsel. And my name's Helen Brady. I'm the Senior Appeals Counsel. Thank you.
Thank you very much. Defense for Mr. Gbagbo.
Merci, Monsieur le Président. Monsieur le Président, à côté de moi, Madame Baron qui est co-conseil, le professeur Jacobs, et derrière moi, Madame Le Guenec, Madame Bobtansky et Madame Bolo. Et quant à moi, je suis Emmanuel Altit, avocat du président Gbagbo.
Thank you. And legal representatives for victims, please.
Good afternoon, Mr. President. For the victims participating in the case appearing today, Mr. Enrique Carnero Royo, Ms. Ludovica Vetruccio, and I am Paulina Massida.
Thank you. Today, the appeals chamber is delivering its judgment on the appeal of Mr. Gbagbo against the decision of Trial Chamber 1 entitled Decision on Mr. Gbagbo's Detention, rendered on the 10th of March 2017. In today's summary, I will refer to this decision as an impugned decision. In a moment, I shall summarize the public version of the appeals chamber's judgment, which was taken unanimously. The summary is not part of the written judgment. The written judgment is the only authoritative account of the appeal chamber's ruling and reasons. The written judgment will be filed in a confidential version and the public version. They will be made available to the parties and participants at the conclusion of this hearing. By way of background, Mr. Gbagbo has been in detention in the court since he surrendered the court on the 30th of November 2011. On the 6th of December 2016, the trial chamber invited the parties to file submissions for the purposes of Article 60, paragraph 3 of the statute, concerning any new developments since its last decision of the review of Mr. Gbagbo's detention. After receiving submissions on interim lease from the prosecutor, the victims participating in the proceedings, and Mr. Gbagbo, on the 3rd of February 2017, the trial chamber rendered its impugned decision on the 10th of March 2017, deciding that Mr. Gbagbo shall remain in detention. On the 20th of March 2017, Mr. Gbagbo filed the document in support of his appeal, and on the 27th of March 2017, the prosecutor and the victims participating in the proceedings submitted their respective responses thereto. I shall now summarize the merits of the present appeal. First, I will address Mr. Gbagbo's first and third ground of appeals as they are related to one another. I will then address the fourth and fifth grounds of appeal as they both relate to the trial chamber's finding on the grounds for detention. I will then address the second ground of appeal. In Mr. Gbagbo's first ground of appeal, he alleged that the majority's refusal to examine the defense submissions continues an error of law. In particular, he submits that his arguments were not a repetition of previous arguments presented to the trial chamber, but supported the current not existence of a pro-Gbagbo network of supporters. In Mr. Gbagbo's third ground of appeal, he essentially challenges the trial chamber's finding as to the existence of a network of supporters, and he raises three arguments in that regard. First, that the trial chamber failed to provide any indication as to the structure and identity of the members of the pro-Gbagbo network of supporters. Second, that the trial chambers failed to deduce any information on the resources at the disposal of this network. And third, that the finding of the trial chamber that the members of the network indeed intend to assist Mr. Gbagbo in evading justice is baseless. With respect to the first ground of appeal, the appeals chamber's first notes that Mr. Gbagbo does not point to the specific new submissions that the trial chambers purportedly failed to address, and that the trial chamber did consider arguments by the prosecutor and Mr. Gbagbo as to whether the network was still operational. It did not need to address arguments that it found were repetitive of arguments disposed of in previous decisions. The appeals chamber therefore finds that Mr. Gbagbo has not demonstrated that the trial chamber erred by not considering his arguments in the network. Turning to the third ground of appeal, the appeals chamber recalls that the impunity decision is a decision taken pursuant to Article 60, paragraph 3 of the statute. A chamber carrying out a periodic review of a ruling on detention under this provision must revert to the ruling on detention to determine whether there has been a change in the circumstances underpinning the ruling. A chamber must also determine whether there are any new circumstances that have a bearing on the conditions under Article 58(1) of the statute. It is crucial the chamber is satisfied at the time of the review decision that grounds remain to detain. The appeals chamber notes that the original decision on detention, as well as the subsequent detention review decision under Article 60, paragraph 3 of the statute, contain findings as to the organization and resources of the pro-Gbagbo supporters and the resources available to Mr. Gbagbo himself. As summarized in the applicable law mentioned earlier, the trial chamber was then required in the impunity decision to address the question of whether there has been a change in circumstances, and in doing so to satisfy itself that the base for those rulings were still current as of the date of the review. The appeals chamber finds that the trial chamber carried out of the required review in concluding that based on the review of the submissions and all material before it, the circumstances had not changed to such an extent as to warrant Mr. Gbagbo's release. While the trial chamber should have been more explicit in this reference to the material which is considered underpinning its decision, as explained more fully in the judgment, in future decision the trial chamber should do this. In this reasoning, in the impugned decision, it refers especially to the new information before it in making this determination. Additionally, the trial chamber correctly considered whether, given its earlier findings underpinning the decision on detention and the new evidence presented by the prosecutor, there continued to be a possibility that members of the network of supporters would break the law. The appeals chamber considers that Mr. Gbagbo has not established that these findings were unreasonable. The appeals chamber therefore rejects Mr. Gbagbo's arguments under the first and third ground of appeal. Under Mr. Gbagbo's fourth ground of appeal, he argues that the trial chamber's majority erred in refusing to consider the accused's age and state of health in determining his release. In relation to the age, the trial chamber notes that taken on its own, it cannot be said that a person's advanced age means per se that he or she will be less likely to abscond or less likely to obstruct proceedings. However, without aiming to set out all of the circumstances in which age may be considered in the context of inter-release, the appeals chamber finds that it is generally more appropriate for age to be considered as a factor potentially in support of release alongside other factors rather than a factor that could evidence a motivation to abscond. Accordingly, the appeals chamber finds that the trial chamber erred. With regard to Mr. Gbagbo's argument that the trial chambers refused to consider the state of his health, the appeals chamber recalls that it previously addressed, in this case, how issues related to the detainee's medical condition could have an impact on a decision as to interim release. It stated that the medical condition of a detained person may have an effect on the risk under Article 58(1)(b of the statute, for instance, on his or her ability to abscond, potentially negating those risks. The appeals chamber observes that there does not appear to be any consideration in the record of Mr. Gbagbo's health conditions in the third decision of the review of detention. For that reason, and for the other reasons detailed in the confidential version of the judgment, the appeals chamber finds that the trial chamber erred in failing to consider whether circumstances had changed such that the risk enumerated in Article 58(1)(b) 1 and 2 of the statutes were impacted. In Mr. Gbagbo's fifth grounds of appeal, he argues that the trial chamber erred in law by basing the continued detention the determination that Mr. Gbagbo has clear intention to abscond given the extreme gravity of the charge and of the fact that the accused denies responsibility. Mr. Gbagbo further contends that the fact that the trial chamber considered his denial of responsibility as the reason in favor of maintaining his detention amounts to a breach of the principle of the presumption of innocence and his defense rights. As to Mr. Gbagbo's arguments regarding the trial chamber's assessment concerning the gravity of the charges, the appeals chamber recalls that in prior jurisprudence, the appeals chamber stated that the gravity of the charges and the resulting expectation of the lengthy prison sentence are relevant factors for decision on interim release. What is important is whether a given factor exists in respect of the particular detained person, whether charges may be similarly serious in respect of some of or all other suspects who are brought before the court, is irrelevant, because even if this were the case, this does not detract from the fact that the charges against Mr. Gbagbo are serious. The trial chamber therefore committed no error in this regard. With regard to the Mr. Gbagbo arguments, as the trial chamber's reference to the fact that he denies any responsibility, however, the appeals chamber find that the trial chamber erred. Under Article 66 of the statute, Mr. Gbagbo is entitled to a presumption of innocence, and under Article 67(1)(g) of the statute, Mr. Gbagbo has the right to be compelled to testify or to confess guilt and to remain silent without such silence being a consideration in the determination of guilt and innocence. As argued by Mr. Gbagbo, taking into account the fact that the person denies responsibility for the charges he faces, as a factor favoring detention would clearly place the detained person in a paradoxical situation. They could either decide to maintain that they are innocent, which could then be taken into account as a factor favoring detention, or accept responsibility for the crimes they are charged with, which in all probability could also be taken into account as a factor favoring detention. The appeals chamber considers that no one should be forced to accept responsibility in order to achieve interim release. The appeals chamber therefore finds that the trial chamber erred. I will now turn to Mr. Gbagbo's second ground of appeal, under which he avers that the trial chamber erred in law by failing to take the time he has spent in detention pending trial into account in assessing whether there have been changed circumstances within the meaning of Article 60, paragraph 3 of the statute. The appeals chamber recalls that it stated in prior judgment that the lapse of time in detention cannot be considered on its own to be a changed circumstance within the meaning of Article 60, paragraph 3 of the statute. Nevertheless, the appeals chamber went on to state in the same judgment that in light of recognized human rights principles, the duration of time in detention pending trial is a factor that needs to be considered along with the risk that are being reviewed under Article 60, paragraph 3 of the statute in order to determine whether all factors being considered, the continued detention stops being reasonable and the individual needs to be released. The appeals chamber observes that, as set out in the judgment, the trial chamber did not address the issue of duration of Mr. Gbagbo's detention and the impugned decision. The appeals chamber also recalls that Mr. Gbagbo has been detained since the 30th of November 2011. The trial began on the 28th of January 2016, and the prosecutor is still in the process of calling evidence. In such circumstances, the appeals chamber considers that the trial chamber should have considered the duration of time Mr. Gbagbo has spent in detention alongside the risk being reviewed, and it should have determined whether all factors being considered, Mr. Gbagbo's detention continues to be reasonable. The Appeals Chamber therefore finds that the trial chamber erred. In conclusion, the Appeals Chamber considers that the errors mentioned previously have materially affected the impugned decision. In light of these errors, the Appeals Chamber decides to reverse the impugned decision and directs the trial chamber to carry out a new review as to whether Mr. Gbagbo should continue to be detained or should be released with or without conditions. Until this matter has been so decided, Mr. Gbagbo shall remain in detention. In making this decision, the Appeals Chamber emphasizes that it is not suggesting what the outcome of the trial chamber's review should be. The Appeals Chamber does not need to deal with Mr. Gbagbo's argument regarding conditional release, including as to how his health condition may relate to conditional release, and as to how the trial chamber refused to consider the possibility of conditional release. This is because the question of conditional release may only be meaningfully addressed once it has been determined whether or not continued detention appears necessary. This concludes my summary of the judgment. I thank the interpreters, court reporters, and parties, and legal officers. The session is now closed.
All rise, veuillez vous lever.